Hello, everybody. Welcome on behalf of all of us at Connecticut Coalition to End Homelessness to the 18th Annual Training Institute and Conference. We're thrilled to have you here today for our first panel discussion, Can They Do That? Understanding and Protecting Tenant Rights in Connecticut. So excited for a really lively and wonderful discussion. We have some great presenters today. This is a really fabulous conference. If you've registered, which you all have, then you've seen that we have an incredible array of different opportunities to explore homelessness through the lens of economic justice, racial justice, and criminal justice, to look at the impact of COVID on homelessness and to explore a lot of different issues relevant to our field. So thank you all for coming, and please do keep spreading the word to people to sign up. It's not too late, and it's free, and we're really glad to have as many people as are interested in learning about homelessness and what they can do about it. I wanted to give a quick shout out to our sponsors, Bank of America and Zillow, who are our presenting sponsors for this year's event. We're absolutely thrilled and want to encourage all of you to, in addition to focusing on signing up for all the different sessions, to make sure you carve out time for today's Housing as a Right discussion featuring Leilani Farha of the Shift, Representative Johanna Hayes, and Senator Saud Anwar from the Connecticut State Legislature. So very exciting, and please join us and spread the word. And now I'd like to turn it over to Fionnuola Darby-Hudgens, who will introduce our speakers. We're thrilled to have Finn here, Amy Eppler-Epstein, Jessica Labrencis, and Michelle Dumas-Keuler here today. So thanks so much to everybody for joining us. Thanks for our speakers, and over to you, Finn.
Good morning, everybody. We're really excited to be here, and I just want to do a quick housekeeping thing as we get started. So if you see the panelists on the right side of your computer screen, you will see that one of our panelists is named Cosign Interpreter. If you are in need of interpretive ASL services, please pin that video you select pin video. And so what you do is on the right-hand corner of the video screen, there is a small blue box with 3 dots in it. Please click that box and an option to pin the video will come down. And that will keep our interpreter services available to you throughout the panel. So without further ado, I want to get started right away. Today's presentation is simply, Can They Do That? And it's going to be a conversation about tenants' legal rights in Connecticut, where we consult 3 housing attorneys who work in Connecticut today. Just quickly before we get started, I want to encourage everybody to follow the organizations represented today on their social media handles, and feel free to tweet at the conference using the hashtag ATI2020. Again, just a little bit of housekeeping. We hope that today's conference we hope that this workshop remains very interactive for participants. And so even though you are on mute, we do have several different ways that we are able to respond to your questions and have you interact with the panel participants. So the first one is you can put questions into the chat window or the Q&A window, and I will be monitoring those throughout the conference presentation. The second thing that you can do is you can tweet at us, and we will get back to those questions as soon as we are able to. So without further ado, let me introduce to you my colleagues and today's panel. Our first panelist is Michelle Dumas-Keuler. She is a human rights attorney with the Commission on Human Rights and Opportunities here in Connecticut. Our second panelist is Amy Eppler-Epstein, and she's a staff attorney with New Haven Legal Assistance Association. And our third panelist is Jessica Labrencis, and she's my colleague at the Connecticut Fair Housing Center. So here is a quick rundown of how today's workshop is going to work. This workshop the goal is to remain very interactive. So we are really encouraging our participants to get involved, which is really exciting. We have several different polls that are available throughout the conference and throughout the workshop, and we're really encouraging our participants to answer those polls as quickly as possible, and we hope to respond to them. Today we are going to address barriers to housing opportunities, and common barriers that we suspect most of the audience has seen for their tenants. We are going to address typical ways that we see housing discrimination affect tenants' opportunity for housing choice And then we're going to do a very quick round at the end where we address common tenant concerns. If time permits, we will do a short Q&A. If, for however, your question is not answered during this workshop, please don't hesitate to reach out to anybody who is presenting or to myself. We are really more than happy. So our first audience poll today is going to be, do you know how each of the organizations can serve you and your clients? I'm going to launch this poll, and this is a very simple question, yes or no answer. Great, I love that we have so many participants on our poll. So it looks like the overwhelming majority are either unsure of how these organizations help tenants in Connecticut, or they really just do not know. So to move this right along, as you can see, the majority of our attendees are either unsure or they simply are really unfamiliar with our organization. So to move that right along, Jessica, are you able to take a moment to explain how the Connecticut Fair Housing Center serves tenants in Connecticut?
Good morning, everyone. I'm Jessica Labrencis. I'm an attorney with the Connecticut Fair Housing Center. We're a nonprofit law firm dedicated to combating housing discrimination. We're based in Hartford, but we operate statewide, and we provide legal advice and advocacy, including administrative representation in administrative cases and court actions. And then the other side of our office defends homeowners in foreclosures and brings cases against banks related to mortgages and fair lending discrimination.
Great, thank you so much, Jessica. I'm going to turn it over to Michelle Dumas-Keuler with the Commission on Human Rights and Opportunities. Michelle, can you explain how your organization serves the state?
Sure. Good morning, everybody. So the Commission on Human Rights and Opportunities is the oldest state-based civil rights organization in the country. And we are the state enforcement agency for the civil rights statutes in Connecticut. That's in employment, housing, public accommodation, which people sometimes wonder what that means. That means if you go to a doctor or a grocery store, the police department, your school, those are all places of public accommodation where you should not be discriminated against, and credit transactions. Our services are provided statewide. We have 4 regional offices and a main office for our housing unit in Hartford. Our services are free. We're an administrative agency, and we're designed to be very easy to navigate. We also monitor the contract compliance, all the money that the state spends on construction. We make sure that a portion of it goes to minority-owned businesses, woman-owned, race, color, disability. And then finally, we monitor the hiring of the state of Connecticut executive branch agencies to make sure that they're representative of the available workforce for the positions that are being sought. So that's what the commission does.
Thank you, Michelle. Amy, if you could take a minute to explain how New Haven Legal Assistance Association represents tenants in Connecticut.
Morning, my name is Amy. I'm an attorney at New Haven Legal Assistance, and we provide free legal services on a variety of civil issues. So not criminal defense for the most part, but a wide range of civil issues, from family law, child protection, education, housing, immigration, public benefits, disability rights, workers' rights, all sorts of civil legal services. We operate in New Haven County, and we are part of a statewide network of sister organizations that operates throughout the state, so you can access free legal services for low-income people throughout any of the legal services. There's a 1-800 number for applications at statewide legal services, and then our sister agencies are Greater Hartford Legal Aid in Hartford County and Connecticut Legal Services that covers the rest of the state. And my office is New Haven Legal Assistance that covers all of New Haven County.
Great, thank you so much, Amy. So before we dive into today's presentation, which is going to be where we really explore different types of scenarios where tenants could potentially face barriers to housing opportunity, our panelists and myself would like to know who is in the audience. So our next poll today will simply ask you which group that you most closely represent with. However, if none of these work for you, please feel free to just simply answer other. I'm just waiting a few more seconds. It's so nice to see that we have so many people participating in our polls. Great. Oh, this is excellent. I love the diversity that we have represented here. So it looks like we really have every organization who could be a key stakeholder in addressing barriers to housing opportunities. Just for our panelists to see, we do have some housing providers, some tenants represented, a few attorneys, and the majority of our audience seems to identify as social service providers. This is excellent. Thank you so much all for sharing that with us today. So we are going to dive right into our case scenarios, and the audience is going to be given an opportunity to try to figure this out before an attorney does answer. So our first case scenario addresses a common barrier to housing that can be in the form of race and national origin discrimination. The case study suggests a person who is homeless speaks Spanish as their primary language and speaks limited English. A caseworker is trying to help this person find housing. They find an appropriate unit. The landlord says, "This is an English-speaking only property, and I will need to see your papers to prove that you are all legal." I'm going to ask the audience, can they do that? Great. I really am loving that so many of you are engaging in the polling. It really helps to keep some of these Zooms a little bit more interactive. All right, so only about 3% of the audience suggested that the landlord could say that to the prospective tenant. 80% of you suggested that no, they could not. And 10% of you were unsure. Michelle, are you able to take a moment to dive into this case study?
Absolutely. I am actually really excited that a lot of people knew that something was wrong here, because that is really half the battle in terms of the work that we all do, is knowing that something is wrong and coming to one of our agencies to ask us about it. Because I think the thing that the Commission and Connecticut for Housing and Legal Services, we are all here to be a resource to you. And so, so for those of you who knew that, yay. For those of you who didn't, that happens all the time. And I want to break this slide into two sections. The first is the English speaking only property. That is not a requirement of tenancy. You know, a requirement of tenancy is paying your rent and being, you know, respectful and a good tenant, and keeping your place clean, all that kind of stuff. I mean, but speaking the language of the landlord is not. And so while we see that happening, it usually is a mask for race, color, national origin, or ancestry discrimination. And so those are all protected classes. Where you were born, whether it be in the United States or some other place, would be your national origin. Where your family's from is your ancestry. Your race and color are your race and color. And you cannot be discriminated against by a landlord if you do not speak the language that he or she speaks. And so that means that the landlord needs to work with you in order to make sure that you're able to rent the unit. And if they choose not to, then that's going to be discrimination. And that's something that you would need to hope, please call one of us about. The other question, which is really disturbing too, is the papers part of it. There is not a requirement that a person be a citizen of the United States in order to rent an apartment unit. Again, you are required to meet those minimum requirements to be a tenant. And I think the thing I want everyone to know is that while we're a state agency, the Commission is a state agency, we do not, we're not in the business of reporting people. We're not, as I've been an employee there for 15 years, and we have not had a situation where we have been asked about immigration status or the cases that we're processing. There's obviously complications to filing a complaint in that you are exposing yourself potentially. But I want everyone to know that we are not reporting it, and I've never known of any inquiries about it. So we're a safe place to come in order to file a complaint. And I can't stress enough, if you don't know, please call one of our organizations. We're here to help you, and our services are free to do that. And it's important that you don't navigate it on your own.
Jessica or Amy, would you like to add anything to Michelle's breakdown of this case study?
I think I would just add kind of an example of why this type of inquiry is discrimination based on race or national origin. And I think intuitively, we know that if a landlord was faced with a potential tenant who came from, say, Sweden or somewhere in Europe, they probably wouldn't ask that person, can I see your papers to prove that you're legal? And I think that's something that is definitely used as a weapon against people from Spanish-speaking countries in a way that it wouldn't be for somewhere in Europe, somewhere like Sweden, somewhere where people tend to be whiter. And so that's why we say this indicates race or national origin discrimination.
Thank you so much, Jessica. Amy, any final thoughts?
I think I've covered it, but I'm glad Michelle stressed that people should feel free and comfortable to come forward to state agencies and to legal services, that we don't do any reporting, and we're not in the business of reporting people's status publicly. So
great, thank you so much. And audience, if you have any additional questions related to this type of discrimination or barriers that are caused by race and national origin discrimination into housing, please don't hesitate to put those questions into our open Q&A, and I will do my best to facilitate those to the attorneys on our panel. We are going to dive right into our next case study, which addresses a tenant who is recovering from substance abuse. We often see this as a type of barrier to housing opportunities. A prospective tenant who is in recovery for alcohol addiction is searching for housing. 3 years ago, the prospective tenant was evicted for lease violations related to her misuse of alcohol. Since then, the prospective tenant completed an inpatient recovery program and then lived with a family member. She has not used alcohol in 3 years. When she applies for an apartment, the landlord rejects her based on her eviction history. Now, audience, I'm going to ask you, can the landlord do this? Really excellent, interesting answers. We seem to be divided across the 3 possible choices as they're coming in. I'll leave the poll open for about another 10 seconds. Great. Well, it looks like we're pretty divided. So 57% of you suggest that the housing provider is able to reject the tenant based on their eviction history. 17% of you suggest no, and 26% of you are unclear. Jessica, are you able to dive into this case study for us?
Sure. So this is a little bit of a tricky situation, and it might be, I think it's a lesser known issue of disability rights, and something that a lot of people may not be aware of. Eviction history used as a tenant screening technique is very, very common, and many landlords do reject tenants based on their eviction history. However, what a lot of people are not aware of is that substance abuse is considered a disability under the Fair Housing Act, as long as the person is not currently using drugs or alcohol. And so in this situation, the prospective tenant has been in recovery for about 3 years and is not currently using alcohol or drugs. So they are considered a person with a disability under the Fair Housing Act. So in this case, the tenant was rejected based on their eviction history, which was directly related to their use of alcohol. The tenant can make a reasonable accommodation request and ask that the landlord overlook the eviction because it was related to her disability and it was directly tied, the lease violations that led to the eviction were directly tied to her disability. So the tenant is in recovery, hasn't used alcohol, so they would be entitled to make a reasonable accommodation request. Now, the landlord doesn't need to just take their word for it. The landlord can request a note from a treatment provider to support the request if the landlord wasn't previously aware of this person's disability history. And it might be helpful for the tenant to also present a note from the family member who they've been living with, who's essentially been their landlord or roommate, kind of showing that they're a good tenant to serve as a reference. So the answer is, if the landlord rejects the tenant initially based on the eviction history, the landlord can't, or the tenant can make a reasonable accommodation request that the landlord should grant. And if people are interested in reasonable accommodations and the ins and outs and more information on that, I would suggest that they Google the Department of Justice and HUD joint statement on reasonable accommodations. There's a lot of great information on the reasonable accommodation process and what landlords and housing providers should be evaluating when they're faced with a reasonable accommodation request.
Jessica, thank you so much. So there's a quick question from the audience, and it's asked, how are we getting this information to renters that may be discriminated against? Would any of you, Jessica, yeah, it'd be great if you could follow up on that.
So at my office, the Connecticut Fair Housing Center, we have a great website with a lot of information on tenants' legal rights. We also have an education and outreach coordinator, and she does presentations for community groups and various organizations around the state. So you can always keep an eye on our website, our blog, or our Twitter, where we sometimes advertise events like these. We have a renter's guide and a homeowner's guide that we send out to all different organizations. So if anyone's interested in getting either a training scheduled or getting any of our written materials, you can reach out to me or Finn, or just send an email to info@ctfairhousing.com, and we're happy to send out any information or schedule a training.
I just wanted to add, the legal services programs around the state have a similar system. You can go to ctlawhelp.org. Eso es en español también, no solamente en inglés, so it's in English and Spanish. And we have a whole variety of pro se, that's do-it-yourself, helping yourself know your rights pamphlets in all areas of civil law that we cover. So that's a great resource too.
Okay, so I'm just going to stop that. We do have a very robust website at the Commission that has its own housing section, that has brochures on what is discrimination, disability discrimination, and the like. You also can contact us directly. We have a CHRO.questions@ct.gov email address. And then we also provide free training throughout the state. And we will, now that we're online, it's very easy for us to conduct webinars, which we do for organizations, and also just in general. So the Commission offers free online fair housing training several times a year. And the next one, very conveniently, is next Wednesday, the 14th, from 9 to 11. It's a general fair housing training. It'll be done online and live so that you can ask questions. And if you're interested in attending that, you can email me directly. And then we'll start again next year. We usually start in February, but we also would do individual trainings also for free. And again, you should contact me if you would like that. Thanks.
Great. And I'm just going to field a few more audience questions specifically about this case study to our panelists. So Jessica, this question is for you. It is definitely a clarifying question, and the attendee would just like to know if the answer is that the landlord can evict the tenant, but the tenant is able to request a reasonable accommodation for overlooking the eviction.
Yeah, I mean, if the landlord doesn't know that the tenant is entitled to a reasonable accommodation, then, you know, a reasonable accommodation request doesn't come into play until a tenant requests it. So, you know, if the landlord has an eviction policy as a tenant screening tool, and they're applying it sort of neutrally across the board, then, you know, they may be able to reject them. Of course, there are other issues that come into play with eviction screenings. They can have a disproportionate impact on people in other protected classes, but that's kind of outside the scope of this question.
Great, thank you so much, Jessica. And I am seeing several questions about attendees looking for more information on all of our case studies and kind of the answers for both tenants and housing providers. I would strongly suggest that attendees explore the websites of the organizations represented today. And I am happy to ask our hosts, CCH, to help me put together just a list of websites for attendees with these resources available. So without further ado, we're going to dive in right to our next case study here that addresses what happens when a tenant has a criminal background. So a private landlord runs a background check. Landlord says to the potential tenant, I won't rent to you because of your results of your criminal background check. The background check shows a misdemeanor conviction for 8 years ago for shoplifting. Audience, can the landlord do that? Love that you all dived right in. This is so fantastic. I'm going to give the polling just another second. Great. We have about 80% participation in the polling. That's really wonderful. And I will share the results. Seems to be pretty divided between yes, no, and maybe. There is an overwhelming majority of people who believe that the landlord is able to create a barrier to housing based on this individual's criminal background. So, Amy, are you able to dive into this case study for our audience?
Yes, I can, and I think those results are really interesting because they reflect sort of where the law is in this area, which is not as clear as I wish it would be. So the law in Connecticut, there is no law currently that says explicitly landlords cannot ask about criminal backgrounds or cannot consider it. It is not, I think most of you know, landlords can't say I won't rent to you based on your race or your gender or your sexual orientation or various other protected classes. Criminal background check is not one of those protected classes. But what the law has found is because of the disparate racial impact of asking about criminal backgrounds and criminal background tests in Connecticut and throughout the country, that can be a suspect class, that can be a grounds for discrimination. And so what HUD has recommended and suggested to landlords, if they don't want to face the possibility of a fair housing challenge, HUD has suggested that landlords, in considering criminal backgrounds, cannot have a blanket policy saying I won't rent to anybody with a criminal background. That would be considered illegal. Landlords are supposed to do what's called an individualized assessment. That means that they look at a bunch of different factors. How long ago was a conviction? What was it for? Was it something that was severe and something that would impact somebody's ability to be a good tenant? And what kind of changes has anybody gone through since that time? So if we were to do that individualized assessment in this case, you would see that you would think that 8 years ago for shoplifting should not affect somebody's ability to be a good tenant. I'm fearing that I am frozen here because I'm seeing a frozen screen in front of me. Are you able to hear me okay?
Amy, yes, we're still able to hear you.
Okay, so we hope the law will change in this area to make it more clear and more explicit, but I think the polling data shows pretty much how it's not as clear an area of law as we hope it will be someday. A lot of people working on trying to get laws to say, to at least put in the laws the kind of considerations that HUD recommends for all tenants. The one other thing I wanted to include is landlords. HUD is quite clear. Landlords can't consider arrest. So at least if landlords are looking at criminal background, they can only consider convictions. They certainly can't consider arrests.
Thank you so much, Amy, for that question. Jessica, would you like to add to Amy's answer?
Sure, yeah. One thing I wanted to add was a lot of landlords will use criminal background screening companies. And we have a case at the Connecticut Fair Housing Center right now that's pending in federal court, where we've recently gotten a decision from the court saying that these tenant screening companies can face liability under the Fair Housing Act due to these criminal background screening products. And so if landlords are using one of these companies to basically make a decision to accept a tenant or deny a tenant based on their criminal records, they need to be very careful in doing that, because the landlord and the screening company can face liability if they don't do an individualized assessment of someone's background. And so it's really important that landlords, to echo Amy, do consider the nature and the severity of the offense, when it occurred, and any rehabilitation efforts that the tenant has made since the time of the offense. Otherwise, they can face a legal challenge, and it's not going to be a defense to say, well, the tenant screening company told me to reject this person. The landlord really has to take responsibility for their own actions and their own tenant screening, despite whatever tools they may be using to help them.
Thank you so much, Jessica. I have a question from the audience related to this case study. And the audience member is asking, can you request a reasonable accommodation request for a criminal background not to be assessed during tenant screening? Who would like to take Jessica? Yeah, thank you.
Sure, yeah, so yes, a tenant can make a reasonable accommodation request to ask a landlord to overlook a criminal background if the incident was related to a disability. This is a very fact-heavy scenario, so it's hard to sort of give examples, but I think if someone had an offense in their background, it was related to a disability, and now they have, completed they're undergoing treatment, or they're on medication, or going through therapy or something that has helped alleviate the symptoms of the disability that led to the arrest or the conviction, then they could make a reasonable accommodation request. I think it would be especially helpful to have information from a treatment provider to support that request, so the landlord is not being asked to just take the person's word for it. But I think that's a good rule of thumb to keep in mind for all tenants. It's helpful to have some supporting documentation from a treatment provider or other person who's in a position to know about the person's disability.
Great, thank you so much, Jessica. And then just a reminder to the audience, because it's coming up through the chat, is yes, this workshop will be recorded and archived, so you will be able to access all this information again as needed. So I'm going to dive right into our next case study. And this one I'm not going to do an audience poll for. I would really like Jessica to dive right in after we allow the audience to consider the questions. So this case study discusses what happens when a tenant was a victim of intimate partner violence. So a tenant experienced intimate partner violence by her former boyfriend at her last apartment. During her tenancy, the police were frequently called to her apartment. The tenant broke her lease during the lease term in order to flee to shelter. The tenant applied for federally subsidized housing. She just received a rejection letter from the housing provider based on a bad landlord reference. The former landlord told the new housing provider that she and her former boyfriend were a nuisance to neighbors who complained about noise and police visits, and that she broke her lease. Can the subsidized housing provider reject her based on this reference?
I would be very curious to know how the audience would respond to this question, because I think it's another one of these questions that's kind of difficult, and it may not be common knowledge what the sort of the legal implications at play here. But so the subsidized housing provider shouldn't reject her based on this reference if the tenant alerts the subsidized housing provider to the fact that the eviction history was related to intimate partner violence or domestic violence. So in this case, the tenant can take advantage of protections offered by the Violence Against Women Act. And for those who are not familiar, the Violence Against Women Act applies to people, both men, women, or someone of any gender, who has experienced domestic violence, dating violence, sexual assault, and stalking. And so a federal subsidized housing provider should not deny an applicant based on something in a tenant's background that is a direct result of domestic violence. So that can apply to a poor rental history, like here, where there's, complaints of nuisance due to noise and police being called, and there's the breaking of the lease by the tenant. But it can also relate to things like a poor credit history due to domestic violence, failure to pay rent, or even a criminal record, like if the police were called and both parties were arrested in a domestic violence situation. So in this case, as I said, the eviction and the noise complaints, or the breaking of the lease and the noise complaints, were due to domestic violence. And so the tenant should inform the housing provider that she'd like to exercise her rights under VAWA. And the housing provider should allow the tenant to certify that she has experienced domestic violence, and ask them to overlook the bad landlord reference because it's related to domestic violence or intimate partner violence. For people who want more information on landlords' obligations and tenants' rights related to Violence Against Women Act, there's a really thorough HUD guidance on this. So if you Google HUD VAWA regulations or HUD VAWA guidelines, you can find really lengthy examples and guidance on how VAWA affects landlords and tenants. And then one other thing I wanted to add with respect to the tenant having broken her lease and fled from the initial property was, under Connecticut law, it's General Statute 47A-11E, tenants who are experiencing family violence or sexual assault can break their lease and move if they give the landlord 30 days notice, and it should be without penalty. So in this case, I think if the landlord was made aware of why she was leaving and was given the 30 days notice, and then he's still giving her a bad reference, that may be in violation of this statute. And so anyone, there's more to it than that. So I would suggest that anyone who's interested in this particular provision just look it up in the general statutes.
Great. Amy, would you like to add to Jessica's analysis of this case study?
I think she's covered it pretty well. So I've got the state statute in there too.
Excellent. And I have a question from the audience. Does this only apply to subsidized housing providers?
So this applies to federally subsidized housing providers, and then also people who have Section 8 vouchers. But I think this is a little bit of a nuanced area that I think is a little bit too big to cover in the time that we have left. But I will say that even for private housing providers, if a tenant is in a situation like this where they have a negative landlord history or a negative rental history related to domestic violence, and the tenant can let the landlord know that and try to explain, and if the landlord refuses to allow them to live there, then there could be an argument that that's sex discrimination under the Fair Housing Act, because women are disproportionately impacted by domestic violence and sort of bear the brunt of the poor rental history that may come along with domestic violence. But if anyone's experiencing that or needs more information, feel free to reach out to me directly and we can chat.
And I just wanted to add the state law that Jessica talked about that says tenants can break their lease if there's a domestic violence situation. That does apply to everybody, not just subsidized housing.
Great. And I have another question from the audience concerning this case study. And the question is, if the client is fleeing to shelter to escape domestic violence, but they have a Section 8 voucher, are they at risk of losing their voucher because they've left their unit?
So the tenant should let the housing authority know what's going on, and housing authorities are supposed to, in their administrative plan, have emergency, I can't remember what the HUD term is, but they should have some type of emergency housing available for the tenant, or a sort of a plan for the tenant who alerts them. But again, there's a lot of details and nuance involved in these types of situations. So I would say check out the HUD guidance, or feel free to call my office, or I think Amy's office probably could handle this as well.
Thank you so much for that wonderful answer. So our next case study involves somebody using a housing subsidy, right? A Section 8 voucher to pay for their rent. So it transitions quite nicely into some of the questions that are being asked by our panelists. And this case study asks, a mother is trying to leave the shelter. She has a new Section 8 voucher, housing voucher, and is seeking an apartment for herself and her 15-year-old son. The landlord explains to the woman that he does not like teenagers. She views the unit and determines it will fit them perfectly. She applies for the property, and the landlord then tells her that the unit is not eligible for the Section 8. Audience, I would like to know if you believe if the tenant can do this, or if the landlord can, sorry, Amy, the landlord can do this. Great, you all jumped right back into polling. I'm so glad that we didn't lose you. I'm going to keep the polling open for about another 6 seconds. Really wonderful response to the audience. Thank you. Amy, these results should interest you. About 5% of our audience suggested the landlord is able to do this. 81% suggested they are not able to, and a good 15% is confused.
Yeah. Well, a great thing about doing these trainings too is it can be very affirming for the folks participating with these polls that you know a lot of the law already. So it's great to know that. And of course, the reason that we do this, as we asked before, is to try to get the word out and to folks like so many service providers we saw are participating today and landlords to know what's allowed and what isn't allowed. So there are two problems here. First one is the landlord saying they don't want teenagers. Second one is the landlord saying the unit is not eligible for Section 8. Both of those things are illegal under Connecticut law because in Connecticut, landlords cannot discriminate against families with children, and that includes all children, whether teenagers, babies, any age children. And also in Connecticut, landlords cannot discriminate based on what's called source of income. And that means that landlords can't say, oh, I only take working people, or I don't take people who are on welfare, or I don't take Section 8, or I don't take security deposit guarantees from the state, or any other legal source of income. A landlord cannot discriminate based on any lawful source of income. So in this case, the landlord saying I don't like teenagers and then saying I don't take Section 8, it's not eligible for Section 8. Obviously, if an apartment doesn't pass a Section 8 inspection, there's the process it has to go through, but a landlord cannot refuse to work with a tenant who has Section 8, and a landlord cannot refuse to rent to somebody because of their familial status, including whether they have children of any age.
Excellent. This is a case we see often in our office. About 10% of the complaints of discrimination in our office are a result of somebody trying to access a housing opportunity with a voucher. I have a question from the audience that asks, if the client has a Section 8 voucher but has no income, is the housing provider able to deny them the housing opportunity because they have no income?
No, it's the same issue because, of course, the way Section 8 works is it's based on 30% of the adjusted gross income of the tenant. So that means that if the tenant has no income for some period of time, Section 8 will be paying the entire rent and might even be paying a utility check to the tenant to cover the utility payments. So no matter what the tenant's income is, if they have Section 8, it shouldn't matter. And it doesn't matter as a matter of law.
I wanted to add one thing, if we have time. This is a little bit of a tricky question in the way that the landlord phrased the denial based on Section 8. The landlord tells the tenant that the unit is not eligible for Section 8. A lot of the cases we see, we might see an advertisement or a landlord telling a tenant, no Section 8, or I don't accept Section 8. But in this case, it seems like the landlord is being a little bit, more tricky by saying the unit is not eligible for Section 8. We also see cases where landlords will tell tenants, oh, Section 8 won't approve, or this isn't a Section 8 approved unit. Those are all discrimination, as Amy said, sort of no matter how it's phrased. And sometimes we'll see cases where the unit will go for an inspection, it will fail for whatever reason. Maybe a window needs to be replaced, or there's something wrong with the outlets in the kitchen, just sort of minor things, and the landlord will refuse to fix it and say, well, I can't rent to you. That's discrimination as well, unless the landlord is removing the unit from the rental market entirely, because if the landlord refuses to fix things for someone who has Section 8 and then rents to someone without Section 8 because they don't have to go through an inspection, that is still discrimination on the basis of lawful source of income.
Just to follow up on the excellent point that Jessica's making, remember that all the what's called housing quality standards, all the things that Section 8 does inspections for and requires landlords to fix, those are all part of the housing codes in the towns and throughout the state. And so it's not like Section 8 is imposing some additional obligations for repairs on landlords that they are not lawfully required to do in any event by the state housing and building codes and the local housing and building codes.
Great. Thank you so much, panelists. We have several questions from the audience coming in about this particular case study and barriers to housing based on the use of a subsidy. So I'm going to permit a little bit more time to answer some of these questions. An audience member asks, can a landlord deny you housing if your income is unemployment insurance?
No, I just got that question last week from a housing provider. The definition is lawful source of income other than employment. And so unemployment is a lawful source of income. I know arguments are made by housing providers that it may be for a short period of time, but there's also housing subsidies that are not Section 8 that are still going to be considered lawful sources of income. And so so unemployment income would be considered a lawful source of income.
I would just note with that, I imagine the basis is a landlord saying, well, you're getting unemployment now, you're not, you don't have a job, so how do I know you're going to be able to pay the rent when your unemployment is over? And although I can understand the landlord's concern, if you rent an apartment to somebody who's employed, that does not guarantee that they're going to continue to be employed a month or two from now. And if you rent an apartment to somebody who's receiving unemployment compensation, that doesn't say anything about, their chances of getting employment before their unemployment compensation runs out. So it's really, I agree with Michelle, that would constitute source of income discrimination.
Mm-hmm.
Thank you. We have an audience member who would like to know if there is any exceptions to the use of a subsidy.
The only exception is for an owner-occupied duplex.
Mm-hmm.
So the only exception that would allow a tenant or a landlord not to accept a Section 8 voucher is if the landlord lives in one unit of a 2-unit building.
Although I would say that is the law in Connecticut. However, I think there would be an argument to be made that if a landlord had a policy of not accepting a Section 8 voucher, that could have a disparate impact based on race or national origin. And so I think they could face a legal challenge that way under federal law.
I do want to add, though, too, that a tenant with a Section 8 voucher still has to go through the general landlord screening process. And so that if they have to be otherwise qualified even if they have the Section 8 voucher. So it's just important to note, too, that if a landlord is rejecting somebody because of a criminal background check or credit, even though they have the voucher, while I wouldn't say there's no case there, because you need to see what they're using as a screening process, who they use it with. Sometimes landlords will not screen all tenants. They may just be screening the Section 8 tenants. So you do want to look further into that, but tenants do need to be otherwise qualified beyond the voucher. And so I think, there might be some situations if the tenant has really bad credit that you'd want to look, you wouldn't just say, yeah, that's fine, but you do want to look more into that.
Thank you so much, Michelle. When we were preparing for this conference, we had lots of dialogue like this, and it was just really interesting to listen to my colleagues. So our next case study involves a tenant who is seeking an emotional support animal. A mother and her daughter enter a shelter. The shelter has a no pet policy. The child experiences depression and anxiety, and her therapist has recommended that she get a dog as an emotional support animal. The mother asks a shelter worker for permission to get a dog for an emotional support for her daughter. The shelter says no because that is their policy. The mother persists, explaining that her daughter really needs the dog for emotional support, and gives the shelter a letter from the therapist supporting the request for the dog. The shelter says the note is insufficient, and they want to review her medical records from the date she was diagnosed. audience, I'm going to have you try to answer this question. And before I pass it to our panelists. I love that so many of you are still with us, answering our polls and paying attention to our extremely smart panelists. I'm going to leave the poll open for about another 5 seconds, but it's great to see over 80% of you participating. All right, Michelle, this question will go to you, so I'll share the results. About 8% of our attendees believe the shelter providers are able to deny access to an emotional support animal. 76% suggest that the shelter cannot, and 16% of our audience is unsure.
Yay. So emotional support animals are probably one of the most contentious or reasonable accommodations that we receive at the Commission. And in housing, and we're going to take the shelter as a housing and not as a public accommodation, the people who live in housing who have disabilities have the right to have an emotional support animal. And the housing provider may ask for documentation if it's not an obvious disability, which depression and anxiety may not be an obvious disability. But asking to seek medical records and to view medical records is going a bit too far. The housing provider can ask to engage in what's the interactive process. If beyond the note, the housing provider wants to have a discussion with the service provider, very limited to the nexus between the support animal and the child's disability, then that's something that can be explored. I think the thing that comes up the most with service animals, and I'm going to run fast through this because I know we don't have a lot of time, is where the initial documentation of the need is coming from. And so we are getting a lot of notes that are coming from these online providers who may not actually really be a treating professional, but are a way that some people may use that method in order to be able to keep what may be a pet, which is not a service animal, in a place that does not allow dogs or cats or whatever the animal may be. So I think it's important to note that you want to be mindful that you have a good note, that these online providers will likely be challenged to the point of us getting an answer about it. We get a few cases with the online providers. They managed to they've never gotten past our housing investigation phase. And so you want to be cautious of that. I think you want to really explain to landlords, though, too, that especially in this time of COVID, there are a lot more. You are engaging with your healthcare provider online. I think in some ways it's really helpful now, because I think a lot of people, that is how they do see their health providers. And so it kind of takes away the stigma from that you might be trying to pull a fast one over on your housing provider. So this can be a very complicated area. Again, I very much advise you contact us if you're in that situation.
Great. I have one very quick question I'm hoping one of my panelists can answer. Is an emotional support animal the same as a service animal?
So an emotional support animal and a service animal, so the service animal provides an actual service to the person with a disability. And so you're going to see a definition of the ADA that a service animal has to provide an actual service to the person who has the disability, and it's limited to a dog or a small pony, which I haven't seen yet. If one of you has seen a small pony, please let me know. And the reason that the small pony is in the definition is because they live longer than dogs do, and it takes obviously a lot of time and money to train. And so emotional support animal isn't necessarily providing a service like picking up the remote control from the floor, which I had a client when I was at the Fair Housing Center. That was what her service animal did. And so there is a difference. Under housing, it doesn't really matter for purposes of a housing provider needing to accept that as an accommodation, because we don't just go by the ADA definition. Under housing in the Fair Housing Act, both state and federal, our definition is much more liberal and allows for emotional support animals of any variety: cat, dog, bunny, lizard, snake, whatever it may be. It's much broader in the fair housing world.
Thank you so much, Michelle.
I wanted to add one thing, just to echo something important that Michelle said, if that's okay, Finn.
Yeah.
So Michelle was talking about the internet-based or app-based therapists. And I just wanted to stress that there's a difference between receiving therapy online like that versus one of these websites that claims to certify your animal and give you like a registration certificate or something like that. Those types of websites, there is no like government registry of service animals or emotional support animals. And so those are basically taking advantage of tenants, having them pay like $75 for a certificate that has no legal meaning. And I think landlords and tenants get confused. Mm-hmm. Landlords will ask, well, is your dog certified or is your dog registered? But there's no significance to that. And so I just wanted to clarify that and say what's important is that the tenant has spoken with a therapist or treating provider or social worker or someone who recommends that they receive the animal, but not, you know, there is no certificate you can print out that has any legal meaning.
I would like to just quickly add before we moved into our very quick yes and no question phase is that if your organization needs assistance understanding the difference between emotional support animals, pets, and service animals, the Connecticut Fair Housing Center partners with CCEH to offer that training several times a year, and we would be happy to bring it back. So our final portion of this is I'm going to pitch these questions to our panelists, and these are common landlord, tenant, and discrimination issues that we see. Amy, this first question is for you. How much money in the form of security deposits can a landlord require at the signing of the lease?
In most cases, the landlord can ask for 2 months security deposit, but if the tenant is 62 or older, then by state law, they can only ask for 1 month.
Thank you so much. Amy, this next question is also for you. If a landlord writes a letter to a tenant telling them they need to vacate their unit by a certain date, and the tenant doesn't vacate, can the landlord change the locks or turn off their electricity?
Absolutely not. If they do so, it is a crime and it's called criminal lockout. They also can't remove the door or do anything that stops the tenant from being able to live there in a secure way. So even if removing the door would constitute a lockout as well.
Great, thank you, Amy. Can a landlord agree to accept housing assistance and then rent to someone else without housing assistance because the paperwork is taking too long?
No, they cannot. The Supreme Court in the 2 Sullivan cases recognized that taking housing assistance might have a few more steps associated with just taking employment income, but that's built into the protected class. A housing provider may have to take a little bit longer, but I think it's kind of a little bit of an urban legend of how long it really takes. And so you do need to go with the tenant that you originally accepted who has Section 8 and not somebody else with employment income because it's faster.
Great, thank you so much, Michelle. And this last question is to Jessica. If a housing coordinator approaches a landlord about a prospective tenant with a rapid rehousing assistance or a security deposit guarantee, and the landlord verbally refuses to accept the housing assistance, but gives a different reason for rejection after reviewing the tenant's application, can they do that?
So this is something that I think housing coordinators experience a lot. And I would say that initially refusing to accept the security deposit guarantee or the rapid rehousing assistance and then giving a different reason later suggests pretext, and it does suggest discrimination on the basis of lawful source of income. So I would suggest that the housing coordinator or the tenant in that situation give our office a call or contact CHRO. The housing coordinator would be a witness in that case. And I think trying to get that in writing would be important in order to establish a case of discrimination.
Great, thanks. And so I just want to take a minute before we close here to acknowledge that we are living in completely unprecedented times that are greatly affecting the housing stability of the constituents we care about most. There are resources available on our website, www.ctfairhousing.org. There are also resources available on www.ctlaw.help.org that Amy referenced earlier. And if you would like your organization to receive any more training or to receive information on COVID-19 moratoria or the fair housing laws, please don't hesitate to email me. My email address is there below. Thank you so much, Connecticut Coalition to End Homelessness, and our panelists for this opportunity this morning. And that concludes our panel.